having a problem understanding what you're losing, what right you're losing. You call it a right to have a federal court try the case, but I don't know that that's a right. You have a right to have recovery for a loss or a potential loss, and the forum where that right is adjudicated is not lost. You have a forum. You have the state court. None of your remedies, like in some of our other cases, would be lost forever. None of your claims or defenses would be lost forever. Canada can file whatever it filed in the federal action in the state action. I've always thought of a statute of limitations as something where you're losing a part of your recovery, a part of your claim. But this is no loss of claim.
Well, Justice Sotomayor, that's why Lozano makes clear that this is a functional test and why you crossed that Rubicon of having to lose a claim.
But tell me what the function is, meaning in Lozano, the question was, did the parent, and we said no, that even though the parent didn't get automatic return of the child, it still got circumstances in which the child wouldn't be returned. If it's non-functional, I still don't understand what right to your claim you have lost.
Right. That's why I point you to Young and also your opinion in Nutraceutical, because in those cases, too, no one lost a claim. In Nutraceutical, there was no right to interlocutory appeal other than that granted by rule, and yet the court looked for a clear intent to preclude tolling.
That's a right to have someone hear the case. So
right.
You're losing that, all right? But here, there is a court, whether it's the state court or the federal court, there is a forum for your claim.
Yes, but in Nutraceutical, you still had the ability to have an appeal at the end of final judgment. You were just losing a mechanism to enforce your arguments in the same way that we're losing our right to removal. And it was the same thing with the IRS in Young. They didn't lose their ability to go after the person who failed to pay taxes. They simply lost the mechanisms of being able to invoke non-dischargeability and priority. But they could overcome those by, for example, alleging fraud as a way to get around dischargeability, or maybe the priority wouldn't have affected them actually being able to recover. So this court in both of those cases was very generous, really capacious in recognizing lower courts' equitable authority, and I think that's why most recently in Haro, the 2024 case, which also involved appeals, the court said the presumption applies to non-jurisdictional timing rules, and this case fits exactly within that.
Thank you.